Hi, hello, how are you all? Welcome to my channel Law Made Simple with me Vidya Reddy. Today, in the series of Public International Law, let us learn about the ratification and reservations of treaties. Earlier, we have learned about the definition of treaty and how treaties are useful in the public international law. Ratification and reservation of treaties. Treaty is the generic term used to embrace convention, agreement, arrangement, protocol, and exchange of notes. A treaty is an agreement entered into between two or more states or international organizations, creating legal rights and obligations between them. This is the definition of a treaty. We have two kinds of treaties, bilateral treaties and multilateral treaties. So, as we have already know the definition from the previous video, let us skip and go into the next slide. Ratification of treaties. After signing the text of the treaty, the delegates refer the same to their governments for the approval, which is called ratification. Article 2 of the Vienna Convention on the Law of the Treaties 1969 defined ratification to mean the international act whereby state establishes on the international plane its consent to be bound by a treaty. Here, ratification is nothing but what the delegates refer to make a treaty, they need an approval from the government. This is nothing but ratification. At one time, ratification was regarded as so necessary that without it, a treaty should be deemed ineffective. But in modern times, the accepted view is that whether a treaty needs ratification or not depends upon the intention of the parties. Article 14 of the Vienna Convention provides that consent of the state to be bound by the treaty is expressed by ratification if the treaty expressly so provides or the negotiating states otherwise agree that a ratification is necessary or the treaty has been signed subject to ratification or for the intention to sign appears from the full powers. So, once upon a time, in early 1970s, there was a real effect of ratification by the governments. But in modern times, the treaty only needs ratification when it is expressly provided or the negotiating states say that ratification is compulsory from the government and the treaty has to be signed only after the ratification and if the intention to sign appears from the full powers. The condition of ratification offers states an opportunity for reconsideration of the text of the treaty and they have a sovereign right to withdraw from it if they so decide. The practice of ratification rests on the following rational grounds also. What are those grounds? States are entitled to have an opportunity for re-examining and reviewing instruments signed by their delegates before undertaking the obligations. By reason of sovereignty, a state is entitled to withdraw from participation in any treaty and often a treaty calls for amendments or adjustments in municipal law. The period between signature and ratification enables states to pass necessary legislation or obtain necessary parliamentary approvals. There is also a democratic principle that government should consult public opinion either in the parliament or elsewhere as to whether a particular treaty should be confirmed or not. So these are the grounds where the delegates refer to the government and seek the advice and also if any amendments or adjustments in the municipal law they apply to the treaty and then only a treaty is signed. So these are some rational grounds where the treaty is ratified. Let us now see the ratification of treaties in different countries. In USA, the ratification of treaties is the executive function of the president with the advice and consent of Senate. In Great Britain, it has become customary for the cabinet to submit the treaty to the parliament before it is ratified in the name of the crown. In India, the making of treaty is an executive function and the municipal courts cannot question the validity of a treaty entered into by the government of India. But when a treaty affects the rights of the Indian citizens or provides for payment of money to a foreign state, its approval to the parliament is necessary. So, here in India also, if there is any effect to the rights of the citizens and there is huge money paid to the foreign states, approval by the parliament is compulsory and necessary and the people of the Indian citizens should really know what the treaty is meant for and what is involved in the treaty. There is no legal or even a moral duty on a state to ratify a treaty signed by its plenipotentiary. Furthermore, there is no obligation other than one of the ordinary courtesy to convey other states concerned a statement of the reasons for refusing or to ratify. So, this is ratification of the treaties. Let us move to reservation of treaties. Article 2, Clause 1D of the Vienna Convention on the Law of Treaties defines a reservation as unilateral statement made by a state when signing, ratifying, accepting, approving or acceding to a treaty, whereby it purports to exclude or modify the legal effect of certain provisions of the treaty in their application to the state. So, reservation is something that it is a unilateral statement made by the state while ratifying the treaties or signing or approving certain treaty. Reservations only apply in respect of multipartite treaties. Here, no bilateral treaties, bipartite treaties will be involved for reservations. Reservations only apply in respect of multipartite treaties. They cannot apply with regard to tripartite treaties also, where the rejection of a proposed provision constitutes the refusal of an offer made and therefore demands a renegotiation of the proposed term. The power of reservation is inherent in a sovereign state. The effect of reservation is to make a fresh offer and the party has the right to assent or reject it expressly or by implication. In case of multilateral treaty, each reservation must be accepted by all parties which have signed the treaty, ratified it or accepted it. The Vienna Convention allows reservation unless the reservation is prohibited by treaty, or the treaty provides that only specific reservation which do not include the reservation in question may be made, or the reservation is incompatible with the subject and purpose of the treaty. So, in the case of multilateral treaty, the reservation is accepted only by the parties which have signed the treaty and ratified it and accepted it. The reservation is allows reservation unless it is prohibited by the treaty, or unless only specified reservation is there, or if it is incompatible, then it prohibits or reservation is not allowed. Incompatibility with the object and purpose of the treaty can relate either to substantive portions of the treaty or to the nature and spirit of the treaty. A convention may provide a mechanism for deciding whether a provision is compatible or not, whether the treaty can be ratified or not, or it is a compatible treaty or not, is provided by by the objection of the treaty. For example, the Convention on Racial Discrimination 1966 deems a reservation to be incompatible if at least 2/3 of the contracting parties object to it. So, in the multilateral treaty, if there is any convention on the racial discrimination and if 2/3 of the parties are objecting it, then that reservation will not be considered. A reservation which is expressly authorized by treaty does not demand the subsequent approval of other contracting parties unless required by the treaty. In respect of a treaty which is constituent instrument of an internal organization, a reservation, unless it is otherwise provided, must be accepted by the competent organ of the relevant organization. If a state objects to a reservation but doesn't oppose the entry into force of the treaty between itself and the reserving state, the provisions to which reservation relates do not apply as between the two states to the extent of reservation. The provision of the treaty for the contracting parties are not modified by the reservation. So, these are the rules to be followed for a reservation and ratification of the treaty.